It looks like we've got everybody who's going to dial in now dialed in. So let's get started on this afternoon's webinar on witness statements in family proceedings. My name's Shárin Diegan and I'm joined by Joanna Gillan, who also practices in the family law team. So today's webinar, as you can see, is going to be focusing on witness statements. It's probably going to be a fairly short webinar. Parts of it will feel like we're covering things that you already know, but there's always quite a lot to be said for going back to the basics and making sure that when you are drafting witness statements, all of those points have been covered. I'll hand over to Jo first. She'll be taking you through general considerations about witness statements in family proceedings, and then I'll deal with more specific witness statements, namely narrative statements in financial remedy proceedings and statements used in Chidren Act proceedings.
Shárin, thank you. As Shárin has just said, we are going back to basics, but it is really important that we remind ourselves of the fundamentals and things that may seem insignificant when you're drafting a statement, but have a huge impact when we get to court, especially when you have a judge that is a stickler for the rules, or when you have a client that is a little difficult in their evidence. Making sure that their statement has been prepared properly can save them and draw them back in. So what is a witness statement and why is it important? A witness statement is, FPR 22.41, a written statement signed by a person which contains the evidence which that person would be allowed to give orally. And that definition is quite important. A witness statement is required where a fact needs to be proved by the evidence of a witness. A party, a witness, is required to serve a witness statement in order to give oral evidence, unless otherwise permitted to do so by the court. That's quite rare. So generally speaking, you're not going to have a witness giving evidence in court unless they've prepared properly and on time, which is very important, a witness statement in advance. The court's use of witness statements. How do we use those witness statements as part of hearings, and specifically in this instance, family hearings? A witness statement will stand different for very new practitioners to criminal proceedings as your client's evidence in chief at the final hearing, unless again the court directs otherwise, and they always have that general discretion, but these are really 99% of the time types of situations that discretion is rarely used, only in exceptional circumstances. A lot of people don't realise, solicitors that don't attend court often or don't sit behind their counsel, that supplemental questions or examination by your counsel to bolster your witness statement is at the discretion of the judge hearing the case. It's not something you just get to do. So it's really important that those statements are full and contain everything you want to say. Obviously, things do arise between the drafting of the statement and the hearing, or counsel sees some holes that need to be filled. And generally, judges will allow additional questions, but it is at the permission of the judge hearing the case. And often they will say, no, everything should be in that statement. A witness called to give evidence at the final hearing may be cross-examined on the witness statement, whether or not the statement or part of it was referred to during the witness's evidence. So it's really important that you remind your clients as you're drafting their statement with them that they need to be consistent. Consistency is so key. And one of the first things that counsel on the other side will say when they're trying to poke holes in your case is that your client has been inconsistent in giving their evidence, and that the judge should prefer the evidence of their client. Permission of the court is required where a party is seeking to adduce evidence from a third party. The permission is required both, importantly, to adduce a statement from the third party and for permission to that witness to give oral evidence. Now, I've seen all too often, actually, situations where somebody has drafted a statement. That's fine, permission's been given for that statement. That's a client, the claimant or defendant or the applicant or the respondent. And annexed to that statement are other people's statement, friends, family, and they've just slipped it in there at the back of their statement in the hope that the judge will read it and take heed of what that particular person has said. That's not how we get third-party statements into proceedings. It's important we follow the rules to make sure that that evidence carries the weight that's intended and helps your client's case progress, because otherwise no weight will be added to that statement at all. A party wishing to rely at the final hearing on the evidence of a witness who has made a statement, the party must call that witness to give oral evidence, okay? And we'll see, yes, at the next bullet point there, that there are provisions and ways you can allow the judge to take heed of that statement even though that person can't come to court. And that's by putting in hearsay evidence. And Part 23 sets out the provisions of that hearsay. And we don't go into detail here, but that's really important that you look at that as well. You can't just turn up at court and say, well, they couldn't come. There are certain procedures that you need to follow to make sure that that statement carries the weight that you want it to. Thank you, Shárin. General considerations. Shárin's going to talk in a little more detail about how to make your statement more applicable to the type of family proceedings that you're taking part in. But generally speaking, a witness statement should set out a truthful record of the witness's knowledge of relevant facts. It shouldn't include a witness's opinion or thoughts on matters. And family proceedings, generally you'll find that there's a little bit of a blurred line with opinions, because often they're giving opinions on their children or the like, or the views of their children, etc. But generally speaking, witness statements should be a truthful record of the witness's knowledge of relevant facts, and that's really important to understand. It should set out the evidence that a witness would be permitted to give orally, avoid analysis of documents and exhibits, expressing an opinion beyond, as I've suggested, relevant to the proceedings in a very limited fashion. Making submissions or advancing arguments. Certainly don't think, oh, I've got a skeleton, an old skeleton from counsel on a case that was very similar to this. I'm going to put in some case law in this statement to really bolster it. That's not going to go down well at all. Each witness statement should be written in the witness's own words. Again, I've had very awkward situations where, generally in civil proceedings actually, but I'm sure it's happened in family cases as well, where my client's witness statement and the witness statement of their friend that they want to rely on is incredibly similar. There are paragraphs in it that are almost identical, if not identical, and then they've just changed the last bit. Don't do that. It's incredibly lazy, and it puts judges off the whole of the case if they think that you've just been using the same statement and putting in bits. It's not a truthful record from the witness's own knowledge. It's really important. It is in that person's own words. Even as counsel, sometimes we're asked to look at statements or help draft them in ways that we're allowed to. Our terminology, the words we use may be different. Your client English may not be their first language. That's important. It's a document that the judge can read and is clear, but it must be in their own words. If you've written a word in that document that your client doesn't understand, it's going to become very awkward in court when they're questioned about it, because it casts a doubt on the truth of the whole statement if they don't really know what that sentence meant. A witness statement should not contain inflammatory language or seek to smear the other party. It should be obvious, but that really doesn't go down well with pretty much all judges, so make sure that doesn't happen. So this is the format of how a witness statement should be set out, and you can find this on these slides if you want to download them after this talk, but there are examples online actually that are easily accessible. It should be fully legible and typed on one side of paper. Be bound in a manner that does not hamper filing. Now, of course, with COVID, you're going to be mostly emailing your statements through, so make sure that, and this is a good one actually, a new one for me, but make sure that if you've sent it to your client and to a colleague and you've all added track changes, that you turn track changes off before you send it to the judge, because otherwise you're going to find, as happened in a very recent case of mine, that all of your comments, which may have been inflammatory or otherwise not very helpful to your case, are still in at the side of your document. So make sure you know how to and have successfully turned off your track changes if you've been sending it around to people with e-bundles at the moment. It should be paginated. Obviously that pagination should form part of the larger bundle, so make sure that your bundle is practice direction compliant, but also that your document is paginated so you can take people through it, your client through it very easily. All paragraphs should be numbered. All the dates should be numbered, expressed in figures, not written. It also shortens the statement, which is very important. And give reference to any documents in bold text, because that's going to help your judge when he's going through things, work out where your exhibits are, or go back to the bit in your statement where you've spoken about a particular exhibit so that the judge can understand a little more about your case. There's also a practice direction there that you should be looking at when looking at the format of your witness statement, so take a note of that, or again, these slides will be available for you after this talk to download. What must a witness statement include? A witness statement must be verified by a statement of truth. Very important, very standard. and we have it there, I believe the facts stated in this witness statement are true. The court may direct that an unverified witness statement shall not be admissible as evidence. You'd have to have a really good reason why that statement is not verified. Proceedings for contempt of court may be brought against a person who makes or causes to be made a false statement. Again, incredibly important. Even in civil cases now, we're dealing with family cases now, but in civil cases, you've got an option now to make applications for your costs, if you're on the right side to do so, where you say that somebody's made up bits of their evidence. And a lot of that time, that's just based on the inconsistencies. If you think, well, they weren't lying, it's just a really bad statement, and there were inconsistencies and they didn't do well. That's why it's so important to make sure your statement is exactly what your client wants to say in their words. Something that is quite niche, if you've not had a client before that isn't able to read or sign their statement. FPR 7.3, make sure that you know the procedure and what you have to do, both for a client that who doesn't have English as their first language, or for other reasons cannot read or sign their statement of truth, that you know what they have to do. The witness statement has been read to the witness. The witness statement, the witness appeared to understand it and approved its contents. That the statement of truth has been read to the witness, that the witness appeared to understand the statement of truth and the consequences of making a false statement, and that the witness signed or made their mark in the presence of an authorised person. Okay, so it must contain a certificate to that degree.
Yep, and I would just add,
Thank you.
I would just follow on from what Jo said about signing witness statements. Even if your client can speak English to a relatively good degree, if English is not their first language and is not the language at which they're going to be giving evidence in court, please make sure that you have considered the need to have their statement translated to them and the appropriate certificate attached to that witness statement, so that you don't run into difficulties at the hearing because the statement's arguably been put in a language which is not their first language and it is not the language that they're giving evidence in.
It's also not a topic we're dealing with in this, but if that's the case and you have to consider interpreters, bringing along a mate who speaks the same language as them is not okay. So make sure you understand the provisions about bringing along interpreters to court and when the judge has to get involved with that. Thank you, Shárin. She's going to tell you a little bit more about Chidren Act proceedings now.
Yep, so witness statements in Chidren Act proceedings, there are a number of ways in which the court may seek evidence from parties in the form of a witness statement. Some of the more obvious ones will be where the witness statement is filed under, for example, an application for a prohibited steps order, a specific issue order, or obviously a child arrangements order. Where we're looking at an application which is without notice, so that's normally where you have your prohibited steps order or a specific issue order, for example, to prevent removal of the child from the jurisdiction or from the care of a particular parent. And slight exception there, a disclosure order under the Family Law Act. The nature of the statement and what it needs to cover will be slightly different to what it might otherwise cover in a statement that has to address, for example, allegations of domestic violence or more generally an application for a child arrangements order. So let me deal with those in turn. Where you're filing a witness statement which is in support of a without notice application, you'll need to ensure that the factual basis relevant to the application has been set out. And wherever possible, please set out facts in a chronological order. It makes it so much easier for everybody who's looking at the statement to understand how we've got to the point that we have and why this application is necessary. You'll need to also include information to justify why the application is being made without notice and why you're saying that the court needs to make the order without notice. So that the court has that information before it. Otherwise, you'll find yourself in a situation where the judge may well say, I don't believe that this is an application that does need to be made without notice. Come back in a couple of days' time and here are the directions for you to make arrangements to serve the other party and put them on notice of these proceedings. So please do make sure that you have included in the statement the reason why you say it's necessary to make that application on a without notice basis. Where you are making an application on a without notice basis, please bear in mind the duty to the court of full and frank disclosure of all material facts relevant to the application. That includes information that does not help your case or help your your application or support your application that you're making, you will be required to provide full and frank disclosure, and the court has a discretion to set aside any orders that it makes where you have failed to comply with that duty. Looking at next, in relation to statements filed where there are allegations of domestic violence, which are going to be determined at a fact-finding hearing. This is distinct from where there are allegations of domestic violence which have not been identified to be determined at a fact-finding hearing. The court will want a statement which sets out the factual basis for those allegations and any supporting evidence. You'll see there that I've also included in brackets reference to non-molestation and occupation orders. I accept that those aren't applications under the Chidren Act, but what you can find is sometimes proceedings will include or within the course of proceedings, a party will make an application for a non-molestation order and or an occupation order, and the factual basis for that application becomes relevant to the facts that the court is being asked to consider in the Chidren Act proceedings, and the court may well consider all of the applications together so that the court resources are being used in an appropriate way. Where you're filing a witness statement which deals with allegations of domestic violence, what I would say first and foremost is have a look at the court directions as to how many allegations you're looking at. More often than not, the court will limit the number of, almost always, the court will limit the number of allegations that it's going to be considering at the fact-find hearing. It's normally about 5 or 6, and you'd normally expect a witness statement to be supportive or to provide further information of the allegations that are contained in a Scotch schedule. That's a table that sets out in tabular form each of the allegations in a short summary, including the date and any other witnesses to that event. And then the respondent will be given an opportunity to provide a response into that table. It's really a document which helps the court with an overview of what's being alleged, and then also the response to those allegations. Where you are filing a witness statement in dealing with allegations of domestic violence, again, this should ideally be put in chronological order so that the court has an idea about how the matters have progressed over time. And if you are the party responding to those allegations, please try your very best to make sure that you respond to the allegations in full. Simply saying, well, that just didn't happen, doesn't always bolster the case very well. It may well be that that is those are your client's instructions, but where there is, for example, an explanation, or your client is seeking to put forward a different version of events, those should be fully set out as clearly as possible within the witness statement. The other way in which the court may look at witness statements or ask parties to file witness statements in Chidren Act proceedings is where there is an application before the court for a child arrangements order or a specific issue order, prohibited steps order, and the court is looking for information about the orders that the parties are asking the court to make and the information to support why the parties have made the application and are asking the court to make a particular order. Again, you'll need to give a factual background, but it needs to be a factual background relevant to the application before the court. The court doesn't need to know absolutely everything that's ever happened in the relationship, including any reasons for breakdown. It's really a factual background so that the court has an idea of how the parties have arrived at the position that they have. You'll also need to set out the basis of the application before the court. If, for example, you had contact, it was going well, and then something has changed, which means that the contact order that was in place is no longer suitable, well, you'll need to set out what the original order for contact was and why you say it needs now to be varied and how you say it needs to be varied. That really takes us on to that second bullet point that you can see there, set out the party's position on issues that are not agreed and refer back to the order. You'd ordinarily see a summary in the recitals about what issues the court is being asked to consider. I would advise that you make sure that you have addressed each of those issues when you are preparing your witness statement, so the court understands what your position is in respect of each of those issues. And then again, outline the parties' proposals for arrangements for the children. What you're ideally hoping for is that you've set it out with enough detail and enough consideration that the court could almost copy and paste what you are proposing, provided you have justified it well enough. So you'll need to give thoughts and consideration to, for example, the frequency of contact, the method of contact, handovers, and any other issues that you anticipate are likely to arise, including, for example, how contact is going to be managed over the school holiday period or other key events within the calendar. For those who are dialing in as litigants in person, I've included a link there to a form of witness statement that the court will indicate could be used by yourself if you are acting as litigant in person and preparing a witness statement in an application for a child arrangements order. That witness statement is accessible online, and you can type into the form online under the relevant headings that have been set out within that witness statement. So it's an additional resource that is available if you feel that that may well be of assistance to you. Finally, just at the last bullet point there, the other way in which the court may ask parties to address matters in a witness statement is in response to recommendations made by CAFCAS, a local authority or an expert. Normally, the court will ask parties to file short position statements in response to a Section 7 or a Section 37 report. But the court may, in very rare circumstances, say it wants it in a witness statement rather than a position statement. Irrespective of whether it's going to be a witness statement or a position statement, what needs to be included in those documents is still the same. You need to ensure that you have responded to the recommendations that are being made. They're normally summarized at the end of the report, and it's helpful if you set out in response to each of the recommendations whether you agree with it or not. If you don't agree with the recommendation, you need to explain why you don't agree with what's being recommended. And if, for example, you have a recommendation that contact should take place on a fortnightly basis and you say it should be more frequent than that, say why you say it should be more frequent, but also explain how you say it should be more frequent. If, for example, you're saying it should be every weekend or alternate weekends and then weekdays, you need to set it out so that the court understands fully what you are asking it to do and what you are saying in response to the recommendations that have been made. And that, I suppose, takes us on to the last point: outline the proposals for the future, ideally to final order. Again, the ideal here is that you've outlined those proposals for the future as clearly and succinctly as possible so that the court could almost copy and paste what you are recommending into an order, provided the court shares the position that you're taking. You need to make the court's job as easy as possible in understanding what you are asking it to do. And you need to make sure that you have fully anticipated how contact is going to work in practice, or how an order is going to work in practice if the court is going to make the order that you're asking it to make in the terms that you're asking it to make it. Moving on to narrative statements. Narrative statements and financial remedy proceedings can sometimes also be known as a Section 25 statement, and that's because this statement addresses the matters that the court has to have regard to when it's considering an order for making a final order in financial remedy proceedings. The factors are set out in Section 25 of the Matrimonial Causes Act, and that's why you find that sometimes it can also be referred to as a Section 25 statement. The court will ordinarily direct that parties prepare narrative statements if parties are unable to settle proceedings at the FDR stage. And what ideally best practice here is to take all of the factors in Section 25, set them out as headings, and address each of the factors within those headings under the relevant heading. What I would say is you'll normally find the court will give a limit to the number of pages or the length of the statements that parties can file. Some factors may well carry more weight in the proceedings that you are preparing the statement for than others. So, for example, if we take, for example, the standard of living enjoyed by the parties, that may well be, in a particular set of circumstances, a very relevant point that the court is likely to give more weight to than other factors. However, if you feel that in your proceedings it's something that the court is not going to give a lot of weight to, then I would suggest that you spend less time addressing that point than you do on other points. For example, if you have a needs argument which you feel is going to be a particularly relevant argument that's likely to carry much more weight, then you need to make sure that that matter has been fully addressed and the appropriate space allocated to it within the witness statement. What I've set out in the next couple of slides is essentially section 25. I've done it because it's a helpful reminder of the things that the court is going to be looking at and the issues that you need to make sure have been addressed in your witness statement. So just looking at that now, you can see that the court's going to have a look at income, earning capacity, property and other financial resources, the financial needs, obligations and responsibilities of the parties, standard of living, the age of each party and the duration of the marriage, any physical or mental disability of either of the parties, the contributions which each of the parties has made or is likely to make in the foreseeable future, the conduct of each of the parties and the value to each of the parties of the marriage of any benefit that that party is going to lose the chance of acquiring as a result of the breakdown of the marriage. Where there are children arising in relation, where there are children in relation to the marriage, then the court has additional factors that it needs to consider. That will be the financial needs of the child, the income, earning capacity, property and other financial resources of the child, physical or mental disability of the child, the manner in which the child has been and is expected to continue to be educated or trained, and then the considerations listed in on the earlier slide. Finally, you may find yourself in a case where there is a marriage that is broken down, where there is a child in that as part of that marriage, but who is not a child arising as a result of the marriage. So where that child has come in to that relationship as a result of a previous relationship, for example. In that case, the court will have regard to whether or not the other party assumed any responsibility for the child's maintenance, the extent to which they assumed responsibility, the basis on which they did so, and the length of time for which they assumed that responsibility, whether that party did so knowing that the child was not their own child, and the liability of any other person to maintain that child. So for example, child maintenance that's being paid or was being paid by the parent to that child. So those are the factors that you should have regard to when you are preparing witness statements for each of the relevant sets of proceedings. It's really just to highlight the things that would be helpful to have fully addressed within witness statements. We appreciate that due to limitations on the length of witness statements, sometimes it'd be quite difficult to ensure that all the information is contained within the witness statement. But certainly setting things out with appropriate subheadings makes finding the information a lot easier, and it also makes sure that each of the relevant points have been addressed in the witness statement. The last thing to look at now is just service of witness statements. What I would suggest is before you even set out arranging for a witness statement to be served, you need to have a look at any orders which relate to the service of witness statements. You'll need to know who you have to serve the witness statement on. In some proceedings, it's fairly obvious. In other proceedings, you may have interveners, you may have third parties, you may have experts, you may have CAFCAS involved. They may well need to be served with a copy of the witness statement as well. So please make sure you have a look at who needs to be served. You also need to have a look at and make a very careful note of the deadlines for service. Joe's already touched on previously the importance of making sure that a witness statement is served on time. So make sure that you've got those dates clearly set out in your diary. It may also be that the court has given a direction for parties to exchange witness statements at different times. So one party filing and exchanging first, and then the other party to follow. So please don't assume that because one date has been set, the parties are filing at the same time or serving at the same time. Finally, you've heard me mention filing. It's whether or not the statement needs to be filed with the court. The court may well say, I don't need this statement to be filed with me, but I do need, but the statement must be served on the other parties, and may specify which parties need to be served with that witness statement. Please make sure that you understand whether or not the statement does need to be filed, because if it does, you'll need to make arrangements to make sure that it is filed on time. You'll see there the last bullet point, the consequences for failing to serve a witness statement in time is that a party may not call that witness to give evidence unless the court gives permission. That's a point Joe touched on earlier, but it's a point worth stressing, that there is a need to make sure that a witness statement is served in time so that parties have got time to take on board what's being said in that witness statement well ahead of any final hearing. That, I think, concludes our very whistle-stop tour of witness statements. If anybody has any questions, please do feel free to raise them in the Q&A function or using the chat function, but ideally Q&A if you've got access to it. We'll do our very best to answer any questions that have come up. What I will say is that the slides and recording, as with the rest of the slides and recordings for the webinar series that Goldsmiths Chambers has hosted, will be put up on our website. We'll circulate details of how to access the slides and the recording after today's webinar. Those will be sent to you by email following your registration on the Eventbrite page.
I actually wrote 2 notes down for myself. One of them I've now no idea why I wrote it, but the other one, quite important for the litigants in person. When there is simultaneous exchange of witness statements, if it gets to 3:54 and the deadline is 4 p.m. and you haven't got theirs, there is no place in the courtroom for tit for tat. You must comply with the direction to file and serve your statement. You can do it at 3:59, doesn't matter, but you must make sure you comply. Don't run the rule of, well, they haven't done it, so I'm not doing it, because then they'll get to see mine and they'll get to reply to everything I've written, and that's not the point of simultaneous exchange. It doesn't matter. You must make sure that you comply so that you're the person that did good in complying with those directions. So don't wait for theirs. The other thing for litigants in person, we talked about there, or Shárin talked about there, the similarities between position statements and witness statements. Know, however, that they're different things. That's not just us changing the lingo and it's the same document. It's not. Witness statements are formal witness statements, and that's what we've been talking about the whole way through this, and you're going to be directed by the court to file witness statements. Position statements are a little bit funny. When you've got counsel or solicitors representing you in court, position statements are something that they will draft. And even if we're not directed, sometimes you'll see when the last part of an order, it says the next hearing will be on date, position statements to be filed, 24 hours, 48 hours beforehand. Sometimes it's silent and your barrister or solicitor will do it anyway. It's something that we as counsel do to assist the court. If you're a litigant in person, you may still want to do a position statement, whether you're asked to or not, or you may want to do it because you've been asked to. Some courts may criticise you for not doing, some won't. It's really dependent on the magistrates or the judge that you're before. But know that it's a very different document to a witness statement, and that's really important to understand.
We've had a question come in about, the question is, how can I make a medical report to count as a witness statement? I think this needs to be broken down into 2 stages. First, medical report. Is this a medical report which is, I suppose, setting out confirmation of a diagnosis of a medical condition, likely relevant to either needs and financial remedy case, or I suppose generally your ability to care for a child or meet their needs in a Chidren Act case. If it's really just confirmation of medical diagnosis, then that's not really necessarily a medical report in the same sense that you would have an expert report dealing with, for example, a psychological assessment of a party. If it's confirmation of your medical diagnosis, really you could make sure that that's attached as an exhibit to your witness statement. You will have seen a bullet point under the format of a witness statement. The very last bullet point there directs you to the relevant part of the family procedure rules, which looks at how you exhibit documents to your witness statement. And I'd suggest you go back and have a look at those provisions to make sure that you do so clearly. You'll need to make sure that you make it clear in your witness statement, again in bold or in the margin, that you are exhibiting, for example, medical report of XYZ in support of the information I provided as to my medical diagnosis here, and then make sure that you've exhibited it in accordance with the rules. If it's an expert medical report, you will need to have had permission granted from the court to be able to rely on that in the proceedings. And I think without further information about how that report's come about, if it is an expert report, I'd be hesitant to give any more guidance on that. But if it is an expert report, that's going to have to be considered in a slightly different way and dealt with in a very different way. So you'll need permission from the court to be able to rely on it. To count as a witness statement, well, it wouldn't really be a witness statement. It would be an independent report by that expert, or it's going to be an exhibit to your witness statement if it's the first type of medical evidence that I've indicated.
And medical reports often, if they're direct, if you've got your permission from the court, which you should have to rely on a formal medical report, the medical reports often contain a statement of truth. So there's a format that experts, when they're preparing reports for court proceedings, follow, that will contain the statement of truth. So it's a whole different bracket of witness evidence, but it's not the same as your client's witness statement at all. And you must make sure you've got permission if you want to rely on a medical report, or at least investigate whether it's necessary in your case, because you don't want to get to court and the judge say, there's no permission for this, so I'm not reading it.
Yeah. Another question's come in. If a position statement is filed containing new evidence that is not contained in a witness statement, is this information inadmissible? Can a party be cross-examined upon the content? I think the difficulty here is, why has it been referred to in a position statement? It's a question about what stage in the proceedings you've reached, whether that information is likely. If it's early stage in proceedings, that information has been referred to, and a party is likely to seek to rely on it at final hearing, well, they're probably going to include it in a witness statement to be used at the final hearing. And if it's included in their witness statement, as Jo touched on earlier, a party can be cross-examined on the content of a witness statement. So that may well be, I hope, one way of answering the question, but without delving into it much further, I'd be hesitant to give.
Position statements generally won't contain a statement of truth, so you're going to have less force cross-examining on the contents of a position statement because it doesn't contain the statement of truth that a witness statement does anyway. So you might be wasting your time. If it's been drafted by counsel and you want to cross-examine the mother on it, well, it was drafted by counsel. Yes, it's on instruction, but it's not her words, and it's not going to get you much further generally. So slightly more difficult if you've got a litigant person who's done a witness statement with a statement of truth and then done a position statement and tried to bolster their witness statement. But again, I think a court's going to be reluctant to say, to make any criticisms of them if they're updating their witness evidence. There's swings and roundabouts, I'm afraid. You have to really just prepare your case as best you can. Don't make silly points that aren't going to get you any further with a judge or magistrates on the day. Don't make a big deal out of a small error by counsel when she was taking her instructions in the note or things like that, because it's probably not going to make the difference in your case. Yeah,
and I think the other point to bear in mind is generally, like, the umbrella discretion that the court has as to how it manages evidence, both in terms of whether you've seen provisions throughout these slides today that the court has the discretion to give permission for parties to rely on or to adduce evidence that hasn't been filed or served in accordance with any of the directions or court orders, that comes in late, for example, or where there are, I suppose, procedural errors, but where the court is of the opinion that it's evidence that it needs to deal with and it's evidence that it needs to consider. So just following on from what Jo's saying there, yes, prepare your case on the basis that this information either is going to go in or isn't going to go in, because it's a discretion for the court and you need to be prepared on either outcome, really.
And a lot of the time, maybe an incident happened between the parties, at pick-up in a child contact proceedings, and it happened 2 days ago and the police were called by mum or whatever. Counsel will often in their position statements quite rightly update the court with the new information, but it's not the words of their client in a witness statement format that is cross-examinable. It is just an update by counsel, so it is different.
Yeah. And that looks like all of the questions. Thank you all very much for dialing in this afternoon. As I said, the slides and the recording will be made available within the next couple of days, and we'll send you an email to let you know how to access those. If you've had any questions arising, or there's any questions that you think of after today, by all means send our clerks an email. We'll be happy to help wherever we can. And equally, if there are particular topics that you feel we could provide webinars on that would be particularly helpful to your chamber, to your firm, please do let us know. Otherwise, have a lovely afternoon.
Thank you.